Welcome to Just Theory. In this episode, we are speaking with Professor Fernanda Pirie, who is a professor of the Anthropology of Law at Oxford University's Centre for Socio-Legal Studies. We discuss her new book, The Rule of Laws, a 4,000-year quest to order the world. We talk about the distinct concept of the rule of laws, the relationship between law, certainty, and power, and how the expansion of legal frameworks can be far from the linear evolution that we'd expect. So, without further ado, I now present you episode 4 on the history of law and order.
Hey, welcome, Fernanda. Thank you so much for joining us. We are absolutely delighted to have you on our podcast. And it would be fantastic if you could say a few words about yourself, about your career. How did you decide to become an academic?
Well, thank you very much for inviting me. I'm very much looking forward to this conversation. So my route into academia was a little bit late and a little bit sideways. So I started off my working life as a practicing lawyer. I went to the bar, having done philosophy and French at university, decided to become a lawyer. I had a very enjoyable time practicing at the London bar. But after about sort of getting on for 10 years, I went off on a holiday to Tibet. A friend of mine said, let's go to Tibet. Why not? And I just loved it out there. And that made me think that I would be really interested in finding out more about how other people live. So I came back and said, do I need a change of career? What can I do? How can I go and spend a year in Tibet?
Yeah.
Lots of people said, yeah, that's all very interesting, but what do you think you're actually going to do? And I ended up talking to a careers consultant. He said, what about academia? And I said, don't be ridiculous. Academia is far too difficult to get into. And he said, well, don't write it off, and encouraged me to go and do a master's in anthropology. So I took a sabbatical from my chambers. That was a very good advice. And it was almost as soon as I started my master's, this was at UCL in London, I realized I was really interested in anthropology and I wanted to carry on doing a PhD. And so I did that. I came to Oxford. I did a PhD in anthropology. And I think because of my legal background, I ended up being interested in and exploring processes of conflict resolution in the Dak part of the Tibetan part of India. So I sort of came back to the law in a very roundabout way via anthropology. And then after that, things fell into place. I got a good postdoc in Germany. I got my current job. I think all of us in academia would acknowledge that there are elements of luck. We have to be sort of in the right place at the right time for it all to come together. But it's also important, if we're doing something we really love, we really enjoy, it's absolutely worth pursuing it.
It's a fascinating story and trajectory, and it's one that to some extent is shared with all our speakers. They all had this mixed background in philosophy and law, history and law, anthropology and law. So I think it's hardly surprising that the most reflective individuals on this podcast are those who actually had a mixed background and a mixed trajectory of their careers. So we are absolutely delighted to have you here and hear your story.
And also, Emilia, I think that the best publications that we've ever read are from people from mixed backgrounds. So anybody who has gone and did either practice and then did something else and then something else again, I think we just know how to write for just normal people, if that makes sense, not for academics. So that's very much my impression of your book. It's an incredibly ambitious project. Having read it,
but also incredibly accessible. That's what I found when I was reading the book. It could be addressed to wider popular audience if they need be, and they will find it absolutely interesting and accessible, whilst academics will find a wealth of knowledge and expertise in that book. So it's a fantastic project.
And I think that would be our first question, or at least mine. Why this title? Why this project? The book consistently draws us back to the rule of law. We include references to Dr. Bonham's case and so on, right? So does the rule of laws point us in a direction of a certain thinner, procedural or formal conception of the rule of law? And from that on, how much of the history of law is actually a history of the rule of law?
Very good question to really go to the heart of the book. In a sort of procedural terms, I came up with that as a focus really as I was writing the book. So it started off as wanting to tell the story of the world's laws for a general audience. And I thought I had interesting things I wanted to say about what law is and what it does, and its great variety. So partly what I wanted to do is explore the different sorts of things that law has been and done in non-familiar, non-Western, non-European based contexts, and to get those stories out for a wider audience. I also wanted to explore what's distinctive about law as opposed to other types of social norms or other ways of organizing society. So there's a distinction I draw in the book between what's distinctly legalistic and what isn't. So hence, ancient Egypt, sophisticated civilization, no law. Other people might disagree with that. So that was basically the sort of the way into the project. And it was really as I was writing, and I think it's typical of anthropology, that it's often as you're dealing with your material that important themes emerge. You realize there are correspondences between different case studies that are worth drawing out. And it occurred to me that there's some element of at least a sort of basic understanding of the rule of law, which occur almost throughout, although not crucially not everywhere. So yes, it's a very sort of, I suppose, basic idea about the rule of law, just the simple idea that rulers and power holders ought to be held to account, and that law is a way of holding them accountable. Law that has an independent existence to not completely controlled by the power holders. So it's that sort of basic procedural sense of the rule of law, which I think recurs very widely throughout many of the examples.
That was actually my first question too, about the title and about how do we really, how should we understand the rule of law as such? Does it mean that the rules rule, so to say, in the objective fashion, that they are standards for conduct, irrespective of who and when applies them? In that sense, they are above the ruler. Or perhaps they are tools of power in hands of those who rule. Or perhaps the truth is somewhere in between. If I remember correctly, Gerald Postema in the common law, in Bentham and the common law tradition, observed that the common law, for example, was this tool or a bulwark against an arbitrary exercise of power by the kings. But kings in turn would exercise their power by statutory law. So you had this clash between the statute, which was a tool in the hands of the ruler, and the common law, which was a bulwark against this arbitrary exercise of power. So I was wondering if you can give us maybe some examples of whether the law is indeed this abstract objective standard that is above human conduct or the ruler, or perhaps it can sometimes become a tool in hands of those who rule.
I think you're absolutely right. And that's one of the really interesting things about law, that it can play both parts. It can perform both functions. And very often it is created by the power holders as an instrument for ruling. And very often it has been something that the rulers, the powerful, have used to control, to manage, to categorize, to exclude for very sort of unjust purposes. But its use to hold the powerful to account is something that recurs. And it's just interesting that those two things carry on pretty well throughout history. So we can see examples either way. So the big example of the context in which the rule of laws never really emerged is China. So there, law was right from the beginning the tool of the power holders. It was something, it was invented by the rulers of the early polities in the Warring States period in 400-500 BC to manage their populations. And it was always an ideology of law being top down and the emperor really being above the law. And arguably, that's a dynamic which continues to this day. The debates about contemporary Chinese law, but but I think it's very plausible to analyze contemporary China in the same way. The party and the party leaders essentially hold themselves to be above the law. So that's the sort of one extreme. Other extreme is probably the religious laws. In the Islamic world, the Hindu world, the Jewish world, where laws were made by the priests and who had an authority that was, for the most part, independent of the political authority of the rulers and the power holders. And very often, you particularly see this in the Hindu world, that the Brahmins, the priests, the lawmakers were telling the kings what to do. They were setting out the way they ought to rule and they ought to resolve disputes. And you also find that tension in the Islamic world very much between the religious scholars who are sort of guardians of the law and the political power holders.
It seems like the story of law from your book is that of dualities. So we have this instrument of, as you pointed out in the media, and it was apparent from Emilia's question, that you have this law as instrument of exercising or curbing power, or we have virtue or a transactional aspect of law, we have formalizing customs or rooting out undesirable behaviors, and so on. You give many of these examples in your book and across history. In my mind, the stronger of the impulses, or one of the strongest of the impulses that drive the development of law, or the expansion of legalism, maybe to be more precise, is this human desire for order and certainty. And this is something that's also a theme in a couple of chapters of your book. I know that in terms of formalizing, especially in the common law tradition, in terms of formalizing the rules or customs, there is an element of willingly giving up, and I hate to borrow Benjamin Franklin's quote in this because it's hugely abused, right? But willingly giving up liberty for safety. Is there any evidence that, let's call them, I don't want to call them lawless because lawless implies negative connotations, so maybe law-free societies or communities progressively over-organize their structures as well?
Over-organized, did you say?
Yes. So is this the laws expanding Leviathan / empire that just begins to, the rules, or which are not formal, even formalized laws, begin to touch more and more areas of life?
Oh, it's difficult to generalize. But there are certainly societies, and any society which feels like a society where there is a sense of order and identity. There are, one would be able to explore the basis for social order, and it may not necessarily be law. So there can be in unwritten customs and traditions, and ideas about how human beings ought to be and to interact. And none of that need be reduced to legalistic terms. So, and a lot of people have resisted legalism for a long time. And I mean, in today's world, it's mostly the small communities where you find this happening, where it's easier for people to turn their backs on the national laws, the state legal systems. But as examples of ancient Egypt, the Aztecs, the Maya show, big complex societies have organized themselves without anything obviously legalistic, without codes of law, without, as far as we know, recording judicial decisions, using them as precedents and that sort of thing. So it's by no means necessary for order.
So I guess what I'm getting at, and what you just said might help me clarify that intuition, whether it's a linear progress from a certain social order by other means, if you will, to legalism and legalistic principles. Or can this be stopped? Because I think in a European / continental tradition, we frequently, the way this is taught is, this was what happened in Babylonia, this is what happened in Rome, Constitutio Criminalis Carolina, and you keep on going, and then here we are now with all of our codes. But it seems like it doesn't necessarily have to be this way.
Yeah, absolutely, very good point. We should query the sense of legal evolution, which can seem very attractive and very natural. Yeah, well, as societies get more complex, they need ways of managing more complex social relations. They invent law or they find law. I mean, in practice, mostly people borrow law from elsewhere. It's a useful tool which they adopt. And then once they're there, there's no going back. To some extent, that is the story of what's happened in several places. But it was certainly not always a need for social order which prompted people to adopt laws. Often it's religious, religious reasons. The laws represented a higher civilization over there, which people wanted to participate in. It's not necessary, but feeling they had the need for law for their own social order. But going in the opposite direction, again, China's a really interesting example here. It had the most sophisticated, powerful, long-lasting legal system that really there has ever been anywhere in the world. It, with various sort of breaks and hiatuses, it more or less lasted for a good 2,000 years, and then pretty well disappeared in the early 20th century. So with the final collapse of the last imperial regime, the Qing dynasty, and also the impulse for modernization. They turned, first of all, the nationalists turned their backs on the whole legal tradition, but then Mao turned his back on laws as well, as he was often doing in communist countries. So now China is developing its own laws very much on the model of Western law, but it's in the middle. There was a long time and it effectively turned its back on law. So it isn't just a one-way process. And there are very different reasons for which people adopt or create or develop laws.
I think the question that, or what you both touched upon, the issue of evolution and the assumption that there is some kind of progress in law is a fascinating historiosophical question and historiosophical query that many philosophers touched upon. Toynbee, Pierre Teilhard de Chardin, most prominently Hegel, who thought there is some kind of movement towards a greater progress in history overall. Do you think, well, maybe I'm asking the same question pretty much, but do you think this claim can ever be validly made of law? I think one of our previous speakers, Aoife O'Donoghue, in her work on tyranny, observed that even modern democratic systems who claim this commitment to human rights protection, to greater values, and to be better than any previous system actually contain hidden tendencies towards tyranny, and they are not as pure and perfect as one would imagine. What's your thoughts on this? Can we ever claim that there is this progress towards a greater perfection?
Or that there's a certain ideal that's universally applicable to everybody, I suppose. I mean, it's an extremely broad question. I think I just made your answer absolutely impossible, but...
Well, it's terribly easy for us to see the model of law that now dominates the world as somehow the ultimate, something that we've all been working towards. And it is really a single model, even though there are lots of differences. It's the style of law developed in Europe. Common law and civilian traditions aren't that different if you sort of really stand back and look in historical context. That's a style of law which has a long history. You can trace it right back to Mesopotamia, I think, through Rome. And that now basically dominates the world. So even Islamic majority countries, which say they base their laws on the Sharia, they have almost all adopted a legal code that's essentially European in form, including modern China and Japan and so on. So it's so easy to see that as the ultimate and assume it's what everything has been leading up to. But then if you look at that next to the traditional Chinese legal system, traditional Hindu legal system, and particularly Islamic laws, these are examples of really sophisticated systems that have developed in quite distinct ways. So they've come and they've gone, apart from Islamic law, which is still very much around. there's no reason to think that the model of law we've got at the moment won't disappear or won't be reformed, or indeed supplemented by something else, a resurgence of Islamic law, or indeed something else.
And I suppose also this claim to perfection and superiority can sometimes be present in systems across the history. So it's not like we progress towards a best legal system. We may claim that it is the best legal system, but it's not necessarily the case. And there is always a potential for abuse and exploitation within any legal system, regardless of what those who put those rules down claim them to be, pretty much. But you did mention actually in your previous response as well, the despotic dimension of the Chinese legal system. And I think in the introduction you mentioned that Montesquieu had great admiration for the Chinese legal system, which, although despotic, was a standard for how a legal system should operate and should work. So my question is really about the wicked legal systems or evil legal systems. Do you think that a legal system which is not advancing justice, perhaps in our parochial Western sense, can be called a legal system at all? So, for example, I noticed that you do not mention totalitarian systems in your book, or do not devote much attention to those. Is it because you don't consider them legal systems at all, because they were evil legal systems? Or even though there is distinction between substance and procedure here, of course, because even if in shape the legal system, a totalitarian legal system, is perfectly fine, the content and substance of that law might not be so. So I'm just asking really about your thoughts on evil legal systems. Can they be called with Radbruch legal systems at all?
Yeah, well, that's a very complex set of questions.
Yeah, I know. I just drifted apart throughout, yeah. but just it made me think of, you know, the idea, like in particular the Chinese legal system, which has despotic tendencies, yet was praised by Montesquieu and others for being effective and a tool of control and order. So I wonder what's your views on this?
Yeah, and I think law is essentially something. It's a tool. It's a style of governing, resolving disputes. So it can be used for good and for bad. So there could be, you know, an entirely despotic legal system, which is still a legal system. But then we also need to look at, I think, substance and procedure, as you said. So a legal system might be legal sort of procedurally. There may be explicit laws which have some sort of objective quality and which are used systematically to resolve disputes, to govern, to manage, to regulate, or something, even in such a despotic system. But substantively, I would say that almost all legal systems, their makers, their promoters, claim some sort of quality for them. There's some sort of idealistic element there, but they may be different. It's not necessarily all about justice. So justice is one of the things that we feel in the current traditions is absolutely important, that a legal system has to promote justice. Even if applying laws doesn't always produce justice, nevertheless, that's an ideal that's out there. But for the Chinese, it was much more about order and stability and preserving the hierarchy, stabilizing the state or the empire, or however they conceptualized it. So that went along with what we might see as despotic and very sort of controlling and not particularly interested in justice as between individuals. It's much more a sort of top-down sense, but that was the ideology. That was what it was all about and what was seen to be terribly important. And then in the Islamic world, much more about God's path for the world, which again, it's not so much concerned about relations, justice between individuals, although a lot of the rules are directed at that, can be used to sort out disputes. But the ideology is very much the larger religious aims of the law. And the law should always aspire to guide people to follow God's path of the world. So people in each of these different traditions, okay, I'm being quite schematic here, would look at another, judge it according to their own, and see it to be different, or maybe wanting, or maybe not perfect. But that's because I think there are these quite distinct ideals that shape the way different people think about laws.
I would also add that when we're talking about the functions of law, one thing that transpired when I was reading, especially about Jewish law part in your book, is how much of the community role it also played, in a sense that we all follow the same rules. Therefore, you can trust me and I can trust you, which is such an idea that's quite alien to us in the West, that there's so much in a society that's based on a certain trust that I know by which values you live and you know by which values I live. Therefore, maybe we don't need the formal government to tell us that I need to give this back to you because we have this set of rules. And I wonder if this is the third dimension that we're just not getting, maybe in the West, and how we design laws. So thinking a little bit more about how we could learn from the religious communities or religious communities of the past, or law-free communities, about how we make our law rather than what we've done or what we've attempted to do for centuries, which is just impose our system on top of the other.
Absolutely. I think there's a real tendency to think that law is something that has to be imposed. There must be systems of enforcement. So hence the doubts as to whether international law is really law. And so what you've just mentioned, that sort of dynamic among the Jewish communities, the Jewish merchants, is very relevant, I think, to contemporary international and transnational laws. Even if there's no world government to enforce them, that doesn't mean they're not important and valuable and effective. I mean, why else is there people making international and transnational laws? They do perform a function. Marty Koskieniemi is very interesting about this. They offer a language, a shared platform for debate. And I've got a student at the moment who is studying the Modern Slavery Act in the UK, which has introduced this very light touch provision for businesses. They've got to create these statements which talk about whether they've looked at modern slavery in their supply chains. It's extremely light touch. And of course, the NGOs have all gone in and said, oh, this is hopeless. It's not going to force anyone to do anything. But what she's showing is that it really must be understood as part of a much broader movement towards business and human rights, towards corporate human responsibility. And the laws, even if they're not, haven't got strong enforcement mechanisms, play a part in that sort of general movement towards setting international standards, towards highlighting the problems of modern slavery, introducing standards which international commercial organizations ought to live up to. And so in some ways, great parallels there with what the merchants were doing almost 1,000 years ago.
I can confirm that because I've drafted these statements before, and the exact response from everybody in the organization was, well, it's just part of our values. It's great to have this training, but what does that statement actually do? It doesn't achieve anything. It just expresses a sentiment that we all share anyway.
I find it absolutely fascinating that now we actually moved into discussing this different role of law, what the law could be, and what purposes it could serve. And since we with the Jewish law, that I found your analysis absolutely captivating. That's a fantastic part of the book. In particular, when you look at the seemingly illogical laws about diet, for example, that we find in the not only Jewish but other religious legal systems. I was wondering, if you indicated at some point that perhaps the reason for those laws, even if there was no strictly dietary justification for those, perhaps there was this desire for categorization and order, distinction between pure and impure, distinction between good and evil, perhaps. What I was thinking, obviously now with COVID pandemic, we have a number of health-related regulations and laws that are then changed every month almost, which seems to be indicating to wider public, is there a true health justification between those if the self-isolation suddenly is for 5 days and no longer 7 days? Or perhaps there is something deeper behind those seemingly health-related rules that current regulations want to enforce. Again, I'm just speculating here, obviously, but I saw a parallel between current health regulations that sometimes make little sense, or the fact that they're changing so frequently. Maybe their role is much more policy oriented, or much more, there is something deeper, something more behind that simply enforcing.
You mean law is political, Emilia?
I didn't say that, but I just wonder if that different role of the law behind enforcing purely pragmatic ends can be identified across the centuries, and including in obviously those ancient religious regimes.
Well, exactly. I mean, it's an example like the laws of Leviticus, the dietary laws, which really highlight this role, the role in creating a sense of purity and identity. You know, we, the Israelites, are the people who follow these laws, and it creates a sense of order, probably in a rather chaotic, essentially decentralized society. So it highlights that aspect of it. And at the other end, of course, you've got the intensely pragmatic rules. A lot of commercial rules are very pragmatic. And of course, we all hope that our politicians are doing their best to introduce laws about COVID or other things which are actually needed to, improve society. We know they're not perfect, but we hope they're doing their best in practical terms. And so it's very easy to ignore the wider symbolic effects that lots of current laws have. And it's probably easy to think of that in terms of a response to a moral panic. Every so often something happens. It's a terrorist incident, or in the UK we've had problems with dangerous dogs or handguns or that sort of thing, and the government rushes to legislate because I feel it needs to be seen to be doing something. And so it's partly about its own status as government, but it's also partly about making a moral statement. These are things that people shouldn't do, even if the laws themselves are not particularly enforceable. And some of the laws on things like hate speech and discrimination, it's very difficult to see them ever being practically enforced in a really useful way. But they make statements, they make moral statements. The COVID rules, I think, they are more intensely practical. But I was struck as well about personal responses to those rules. Most people are fairly law-abiding, and if the law says this is what we do, then the law changes, and then all of a sudden we're allowed to see more people or mix in different ways. And people switch their behavior. And you think, well, COVID hasn't just suddenly switched like that. Why don't people regard the law with a bit of skepticism and try to make their own minds up? Maybe again, there's just a need to follow something, a need to believe that there are greater minds at work doing their best, introducing the best rules. We don't have to think, we can follow the rules and just hope that this is going to have the best outcome.
There are some psychologists that say that uncertainty is the biggest fear and the biggest burden for humanity. So we are willing to delegate almost any aspect of our life that can potentially cause us uncertainty and anxiety, just so we can lead just an everyday happier life. But I think what you touched upon is very interesting, because those are my musings as well around the pandemic. And I know, Emilia, we talked about it. I think a lot of the members of the legal academia and the community talked about it, about how easy it is to change laws and shift behaviors. But what was almost more interesting to me is that this is just small changes. This is things that people notice because they impact their everyday life. So, today I need to wear a mask to the shop, tomorrow I don't, right? But when we are faced with a crisis, there is an impulse, and well, there is evidence that there are some governments that try to exploit it. So when we look back at the US, right, what happened with the Patriot Act, all of a sudden everybody became very comfortable with a lot of things that under normal circumstances they would not be very comfortable with. And you think about it, and you never hear the government taking this boundary back after the crisis is over. So it's almost like the system of law is expanding, but it's not really that fond of contracting back in place. And I wonder, throughout centuries, and it brings us back really to the beginning of our conversation, is this really this ever-expanding empire that you can only stop if you change it to a completely new thing?
I mean, that's a very good question. You do see other legal systems expanding a little bit out of control. I mean, arguably that's what happened with Roman law in the late Republic, when the jurists got hold of it. And it became an academic exercise, and they wrote one opinion after another, and they got more and more esoteric and impractical. And people say the same thing about certain contexts of Islamic law. The Islamic legal scholars were creating these small masterpieces of legal interpretation that nobody was ever going to use. And you can see this in medieval Ireland, the scribes getting really interested in fine legal distinctions. So there's that tendency always, I think, certainly when the scholars get hold of the law. Well, maybe what you're talking about is a slightly parallel tendency for governments to create ever more laws and rules and regulations. And certainly in this country, in the UK, there's been a movement to try and simplify the law. There's been concern about too much lawmaking. It does get debated in Parliament every so often. Can those sorts of reform movements lead to a change, a reduction? I don't know, but I certainly agree that there's a tendency for both scholars and governments to, when they get hold of laws, to sort of increase what they do with them.
So there is a curious example in Poland, in a Polish civil code. That's the biggest code the country has. It's massive. And you have all of those, contractual and other laws that you would expect in a civil code. And then all of a sudden you have this minor provision for beehive owners. And I know it's what to do when your beehive disappears or something like that. And it's almost like an anecdote that people share to this day. And there's been multiple projects by academics to push for the reform of this civil code and to make it what the civil code actually should be. But all of them really failed. So it seems like even if you have this really weird body of law that contains everything in it, because somebody just, a thoughtless legislator decided to just dump all the ideas in the same place, it's very difficult without this internal impulse from the government to actually change anything.
Indeed, it sort of needs, well, once a legal system gets a momentum of its own, it is quite difficult to stand back and completely reform. It's quite a revolutionary act, if you think about it, which maybe goes back to what we were talking about originally about the rule of law. There's an idea that law has a sort of independent existence and that it should be something which holds the power holders to account. So if the government and the power holders come along and say, right, we're going to change the law, I think people are rightly pretty suspicious of that and nervous about what they're going to do. But I just want to follow up on the beehives. I mean, it's just such an interesting example because you find rules on beehives in the oddest places. So the Irish, and I mentioned this in the book, made these really complex laws about how farmers could chase swarms of bees across their neighbour's land. Quite impractically complicated, but clearly this was an issue. I had a student who looked at laws in Kosovo, and some of the traditional laws were based on Islamic law, had these complicated provisions about beehives. What is it about bees which leads to these complicated laws? Maybe it's because it's a sort of property which moves around in an uncontrolled way. So it represents a sort of exception to our laws of property, and therefore of great interest to legal scholars.
It's interesting what you just said, because this is literally what this entire provision is about. So you have, it's not even about protection of animals, because there is a separate legislation for this. It is quite literally about what the owner of a hive should do on several different occasions.
The two things that emerge from this conversation really is that law contains this tension or struggle between a commitment to generality, general laws that can embrace all sorts of situations, and particularity on the other hand. So you've got laws which are as particular as those on beehive, and the question remains: are they even laws in a grand sense at all, or they are just regulations that govern practical affairs? So that's one thing that emerged from this conversation to me. And the second thing, it seems to be that the law is actually a product of this dialectic between pragmatic purpose, pragmatic pressure, and ever-changing context. And the legal responses to it. So when we were talking about COVID earlier on, and all sorts of emergencies, they seem to be new impulses which do not really invalidate what was going on before, but perhaps there is new information which comes forward, and suddenly a new law is simply a response to what was going on, which does not invalidate what was going on before. It was simply, we need to change the law in response to the novel context. It doesn't make the previous law any worse. It's simply a different response to a different piece of knowledge. Like with COVID, perhaps scientific knowledge changes as well. We cannot claim that this means that the previous laws did not respond correctly. Maybe in the past the knowledge was different, and now we've got new discoveries. So we need to, so to say, dialectically respond to this. But there is also a deeply political dimension to it, I think. So I'm not sure if you both aware yesterday, the announcement was made that there is a potentially unlawful interference in the parliament from China in the shape of this agent. And Priti Patel mentioned that one of the reasons as to why this announcement was made is because she's got in mind an introduction of a new legislation, which I don't know what this legislation is going to be, but I wonder if this is like a interlude to introducing something fairly controversial anytime soon in the parliament. Again, I think I mentioned too many things now, but this is just my kind of reflection of what was emerging from the conversation between the two of you.
I think you're highlighting the ways in which sort of pragmatism and politics and opportunism, they all sort of revolve around the making of law. And it's easy to look at a legal system and think, oh, well, why did they make this law? And to assume it was a perfectly logical reason behind it. And we all, especially if we go back in history and we don't have an awful lot of knowledge about the context, we've always got to bear in mind that there are multiple reasons for which people make laws, and that they needn't necessarily reflect what was actually going on. So especially some of the really draconian sort of laws which you see in some of the ancient codes, shouldn't necessarily assume that's what the judges were doing. There may have been all sorts of other reasons they wanted to make laws in those forms.
I'm quite mindful of time, so perhaps we will soon proceed to, but I have one more question actually before
that's always the problem. We always face the same issue. We never run out of questions, but there's one thing I really wanted to touch upon, and I promise I'll be very brief. So when you talk about the history of law and the rule of law, you also talk about a history of government in a way, and organized societal structures. So when we think about the distinction between the normative frameworks and the formalized law, and we have this Aristotelian law as virtue, and we have the diversity of legal function that we have today, right? I began to think about the role of judges in all this, or some kind of adjudicators. So you write about the Roman praetors, I think that's how you pronounce it in English, primarily concerned with using their office also for political gain, and you have the Platonian experts who decide on a case-by-case basis. So I wonder, do adjudicators in lawless communities or law-free communities apply informal rules in a law-like manner? And is the judicial function in a way conditional on having some formal legal structure?
Well, I think the important distinction is between adjudication and mediation, or judges and mediators. So almost everywhere in the world, you find some system for resolving disputes, and they can be very different. But without explicit laws, there are generally processes of mediation, trying to bring the parties to agreement, discussing the case in all its particularity, appealing to general moral principles, and trying to work out a suitable solution in this particular case. With the introduction of legalism and legalistic rules, general rules that can be applied to whole classes and categories of people and things and events, that makes possible a different style of conflict resolution, namely adjudication, which we associate with judges. And in practice, of course, those two things are often mixed up. Mediation goes on all over the place, even alongside systems of adjudication. But I think it's that basic distinction we need to bear in mind when trying to understand the role of judges or adjudicators. And it is very different, because in one case it's saying, make a definite decision. This is right, this is wrong. This, you are in this category, your conduct in the event is in this category, therefore the answer is this. It's much easier to make a decision by doing that, rather than trying to get all the parties to come to agreement. But it's the situation in which justice is not always done simply by applying a rule.
Just one more quick one, if I may. That's the question of sovereignty, really. Because you did mention, or you make a claim at some stage that modern legal systems are really emerged from Chinese, Mesopotamian, and Indian traditions. So they are not truly original legal systems. And can we, if our modern Western legal systems so committed to sovereignty are really products of past very distinct tradition that they are not willing to admit they are, can we even speak of sovereignty or sovereign legal systems today if they are really products of what was going on in the past? I mean, you know what I mean? I'm just trying to, because there is is question of sovereignty really a procedural question of structure, or is it again substantive question of who rules and how and what's the substance of the law? So I suppose these are two separate questions, but I think we tend to add some kind of veneer of superiority to our law as truly distinct, original, sovereign.
Yeah.
And then cite Roman rules, like that's my favorite. And on the continent, it happens all the time. You say we are also special, and then you cite Roman rules in Latin.
Yeah. And the common law, of course, developed this great ideology that, it's ancient tradition, it's our tradition, and it's all been formalized in the common law. And of course, an awful lot of it is borrowed from or inspired by the continental Roman and civilian traditions. So I suppose, maybe those are two quite interesting tendencies you see in the history of law. On the one hand, sort of the ideology of it's ours. We developed it, it's for our people, it's what makes us distinct. And then in other contexts, yes, we're following this wonderful law. It's all based in Rome. They have the most superior legal system. So certainly in early medieval Europe, when the Germanic kings were making legal codes, they almost certainly had the image of Roman emperors behind them. And you see that in the Islamic world as well. Legal borrowing has been so common. And in those circumstances, people almost certainly, often explicitly, as it were, linking themselves with something historical, traditional, seemed to be superior. So again, it's one of those sort of dichotomies. You see a bit of both in different contexts.
Okay.
I will let you conclude now, Emilia, because I think there's always a problem with a book that rich that we can just keep on going. Themes of anarchy, for example, or even adjudicating in anarchy would be super interesting. And I know you've done some field work as well, which we didn't get the chance to ask you about. But what I would say before we move on to the academic question, to the final bit of the kind of know-how building for future academics questions. I really enjoyed reading your book, and I know Emilia as well. And I think we would recommend it genuinely to anybody who's interested, who's even questioning now, when we talked about COVID, who's even now questioning, why do we have laws?
I would in particular recommend it to those abstract legal theorists who fail to kind of realize
take on the human side of things,
and contextual, because this is something very often overlooked in legal theory, that we show commitment to abstract constructs and concepts, whilst often neglecting pragmatic historical background. And I think that book perfectly helps us to fill in that gap. Okay, so Aleksandra, over to you and the questions, because I don't even have them in front of me. So there you go.
Who or what was your biggest inspiration in your career?
Yes, a difficult question. I mean, I could think about people or things that were inspiring, in anthropology, in Tibet, in law. But I think maybe I should mention here my father, a school teacher, for two reasons, really. One is that he taught me to take an interest in people. I remember when I first went off traveling as a school child around Europe, and he said, don't just rush around and look at all the big capitals. Go to a place, go to somewhere in rural France, and just try and stay there and get to know it and get to know the people. And that sort of instinct to look at things from the inside, to understand them on their own terms, I think was very inspiring as I moved into anthropology. And indeed, looking at legal history, I think even if all we have is a text, it's important to just think, well, what does it mean? Who wrote it? Why? What was in their minds when they were doing this? But secondly, he was very insistent on writing clearly and simply. He would read my essays and say, yes, but why did you use that word? Or what did you really mean by that? And I do think that's terribly important for academics, to write in a straightforward, accessible way, to avoid too much academic jargon. If we've got good ideas, we can almost certainly express them simply. We don't need the jargon. So I often have his voice in my mind, on my shoulder, saying, why are you saying that?
You can really tell with the book. I think it's a definite testament to that message, I have to say. What do you wish you could tell your graduate student self?
Yes, well, I think sort of slightly embarrassingly, maybe, I would say something about the importance of networking. And I say it's a bit embarrassing because I do think that what's important for us as academics, students moving into academia, is the quality of what we do. We need to aspire to be good researchers, good readers, good writers. We need to publish in good journals with good publishing houses. But it's not enough. I think I was a bit naive when I was a graduate student and thinking that was all that was important. We do have to network. We do have to get out there. We do have to have conversations like this, which has been great to get our ideas out. That doesn't mean over promotion, self-aggrandizement, but I think in the academic world, we do need to work on these networks, develop the conversations, get the ideas out.
I suppose the pandemic is both a an opportunity and obstacle here, because we couldn't see each other in person, but it led to this development of Zoom and all sorts of interactive platforms that we can all benefit from and should benefit from.
That's a difficult one, and everybody says that's the most difficult one. If you could only read one book for the rest of your life, what would it be?
Yeah, very difficult. And I suppose it's a bit like Desert Island Discs. You're going to give me the Bible and the complete works of Shakespeare, so I don't have to take those. I think if I was going to carry on, working on academia, as I assume I would, on my desert island or otherwise, I might take a book of philosophy. I might take J.R. Austin, How to Do Things with Words, partly because there's so many interesting things to think about in there, which I think are generally useful across a lot of range of subjects and styles of writing and so on. I think it would be very useful.
Perfect. If you had not been an academic or a barrister, may I add, what alternative career would you have chosen?
I think I'd have been a landscape gardener or an architect. Two creative things.
It's always been... It's so strange, because I've been just talking to somebody about how I wanted to be a baker at some point in my life. When you have a really tough day, do you also think to yourself, oh, I should have been a landscaper?
I suppose all of these professions have to do with order and following instructions. So perhaps there is more commonalities between those than we think.
But I think it's also the counterpoint. As you say, you come to the end of a long day and you think, oh, why aren't I out there dealing with the material world? I think it's what both of those involve.
Mm-hmm.
And a final question, finish the sentence. One thing no one talks about in academia is?
How unethical our ethical procedures are. I'm afraid that's one of my bugbears. I think, we are all over the place with ethics procedures, and they need a lot of radical rethought, because ethics is too important to be left to the sort of bureaucratic systems we have at the moment.
I would imagine working in anthropology especially, that would be a particularly sticky point.
Exactly. I'm not sure I could have done my 2 bits of field work with the current ethical procedures that are in place. I did them before the current system was in place. They are very bad. The procedures are very badly adapted to anthropology. And anthropologists always worry a lot about ethics. They discuss it, and it's always a matter of working out a particular situation, what's dangerous or not, what's right and wrong, and bureaucratizing the whole system is just a disaster.
Brilliant. Well, we're almost bang on time, so thank you very much. It's been a pleasure. Emilia, would you like to wrap up?
Yes, thank you so much. It's been incredibly interesting and fascinating to read your book, which makes plain that law is one of the wheels of civilization, which we tend to forget in terms of its historical impact, and that your book made it perfectly plain that we are here. We didn't emerge from a vacuum, but from a very rich tradition, which we often fail to acknowledge. So I thank you for it. I thank you for your interview here with us. And I hope that you will have a wonderful rest of the day and the week.
And we get to meet in person at some point.
Indeed, that would be a pleasure. And thank you so very much for your very kind words about the book. And it's been a real pleasure to talk about it to people who've read it so carefully and thought of so many really interesting and challenging questions to ask about it.
Thank you.
Hi, it's Aleksandra here. Thank you for listening. We hope you enjoyed this episode. If you like our project, have any questions, or would like to recommend a guest or a topic, drop us a line on just.theory.project@gmail.com. This season was made possible with the generous funding of Newcastle University. If you like, you can buy us a coffee. Your support will enable us to continue our work. Just Theory, changing the face of legal theory.